pleading the matter of the Secretary of State for the Home Department and the Queen on the application of Khattak.
Right. Mr. Zain Malik, and you'll understand why I call you Mr. Zain Malik. You can take it that we have read the judgment, the skeleton arguments, the grounds of appeal.
Very grateful. So, my ladies, my lord, I appear for the Secretary of State this morning, who is the appellant. Mr. Bilal Malik appears for Mr. Khattak, who is the respondent. My ladies, my lord, the issue in this appeal is whether Mr. Khattak is eligible to apply for leave to remain as a partner for the purpose of paragraph L, TRPT 2.3, small b, Roman 3 of Appendix FM to the immigration rules. I shall seek to persuade my ladies and my lord that the answer to this issue is yes, and that the upper tribunal erred in answering it as no. There is no dispute as to the background facts. They are set out in my skeleton argument at paragraphs 3 to 12. I will not take the court's time on the facts, save as to highlight that Mr. Khattak is in a relationship with Ms. Razia Begum, who is a British citizen, and they have been living together as a couple since December 2017. On that basis, the Secretary of State concluded that Mr. Khattak was eligible to apply for leave to remain as a partner and therefore not entitled to leave to remain as a parent of his child from a previous relationship. Before I take the court to the relevant rules, may I make a very brief submissions as to their nature and the proper approach to their construction. The rules are made under Section 3, Subsection 2 of the Immigration Act 1971. They are statements of the Secretary of State's practice to be followed in the administration of immigration control. They should be construed with a recognition that they are statements of administrative policy, not the law of the land, and they should not be construed with the strictness that is applicable to the construction of a statute. One must not look at solely at the language of the rule in question, but the immigration rules as a whole and the function that they are meant to serve in the immigration policy. And the ultimate question for the court is what the Secretary of State intended her policy to be. The authority for that proposition is the judgment of the Supreme Court in Mahad. You have that in the authorities bundle. It's behind tab 6. And the relevant paragraph is paragraph 6. Sorry, the relevant paragraph is paragraph 10. This is page 262 of the bundle. Right at the end of that page, the court will see paragraph 10, which refers to what Lord Hoffman said in MO Nigeria. If you look at the next page, page 263 of the bundle, you'll see that the relevant passage is underlined. And if you look between letters C and E, you'll see that the question of interpretation is what the Secretary of State intended his policy to be. So in that way, the approach that applies to construction of the rules is different from the approach that applies to construction of primary legislation.
And we see there that the intention is to be discerned objectively from the language used, not divined by reference to supposed policy considerations.
Absolutely, absolutely. But you have my submission that one should not be looking simply at the language that is used in the rule in question, but also the context and the rules as a whole. Milady, if you look at the very first line at that page, page 263, that makes the point that one has to look at the rules as a whole and the function which they serve in the administration of immigration policy. So that is Mahat. In certain circumstances, it is fair to point out that it's legitimate to have regard to the Secretary of State's published policy in ascertaining the correct meaning of the immigration rules. But it's not permissible for the Secretary of State to rely on an extraneous document to persuade the court to resolve an ambiguity in the government's favor. The authority for that proposition is Pokrial. I do not propose to take you to that authority. The proposition is uncontroversial. It's behind tab 5 of the bundle. The relevant paragraphs are paragraphs 42 to 43. So with that in mind, if I may now take the court to the relevant rules and make some very brief submissions. So the relevant rules are behind tab 1 of the authorities bundle. So this is Appendix FM in its entirety. FM, as you will see from the heading, stands for family members. The very first paragraph, this is Gen 1.1, identifies the purpose of this route, the purpose of Appendix FM as a whole. And you'll see that it is for those who seek leave to remain on the basis of their family life with a person who is a British citizen. So this is the general purpose. So this general purpose applies to all categories, all routes within Appendix FM. You then have a section with the heading Definitions. That is Gen 1.2, and it says that for the purposes of this appendix, partner means, and the relevant subparagraph is subparagraph 4. A person who has been living together with the applicant in a relationship akin to a marriage or a civil partnership for at least 2 years prior to the date of the application. And then there are words that I place particular emphasis on, unless a different meaning of the partner applies elsewhere in this appendix. So the purpose of this definition, in my respective submission, is obvious. This is to ensure that the relationship of an applicant with the British citizen partner is sufficiently strong. They must be married to each other or in a civil partnership, or they must have lived together for 2 years. So that is the general purpose, designed to ensure that the relationship is sufficiently strong before an applicant is given leave to remain on the basis of a relationship with a partner. Now, I respectfully ask the court to compare the language that is used in Gen 1.2 Roman 4, the language that you have just seen, unless a different meaning of partner applies elsewhere in this appendix, with the language that is used in Gen 1.4. If you look at Gen 1.4, in this appendix, specified means specified in Appendix FMSC unless otherwise stated. So where the immigration rules require an express exclusion of a defined term, this is the sort of language that they use. If the rules had intended the definition of the partner to be expressly excluded from the subsequent sections, one would have expected similar language to be used in Gen 1.2. But the language that is used in Gen 1.2 is flexible. It does not require express exclusion. If you then...
Sorry, so the difference is what between the words stated and applies?
Absolutely, yes. Unless different meaning applies elsewhere and unless otherwise stated. So when it comes to words specified, unless it is expressly stated in this appendix that that meaning would not apply, the meaning would apply. But that is not the approach that in my respectful submission applies when it comes to the meaning of the word partner. It is more flexible in its application. If you then go to page 12 of this bundle, sorry.
Can I just stop you there?
Yes.
In this appendix, specified means specified in Appendix FMSE unless otherwise stated. Why aren't we entitled, or why isn't someone who's seeking to rely upon this guidance entitled to say, well, unless otherwise stated, specifically includes Gen 1.2, which says a different meaning of partner applies elsewhere in this appendix? I mean, they're not mutually exclusive, are they? Because that is specified, a different meaning applies elsewhere in this appendix.
Well, the word specified has a particular meaning. So it contemplates submission of specified documents. For instance, they are set out in Appendix FM SE. SE stands for specified evidence.
Right. So why do you take us there at all? Because if we're looking at a different meaning of a partner applies elsewhere in this appendix, where else in the appendix do we see the different meaning of partner?
Well, the submission is that, firstly, the reason why I've taken you to Gen 1.4 is this, that in Mahar, the authority that you've just looked at, apart from paragraph 10, and if needed, I'll take you to the relevant paragraphs in a minute, Lord Brown identified a helpful tool for construction of the immigration rules. He said that it's legitimate to compare the language used in two different rules to ascertain the proper meaning.
All right, so we've got that point. Where else in the appendix is there a different meaning of partner?
There isn't expressly within this appendix a different meaning of word partner.
So,
apart from the one we're going to have to look at.
Absolutely. And
is that the only time where there's something other than you've got to be with them for 2 years?
Well, there may well be. It may well be that different meaning applies in a different provision.
Well, no, I'm just talking about the specific Gen 1.2, which gives a specific definition.
Yes.
For the purposes of this appendix, unless a different meaning of partner applies elsewhere in this appendix. Is there any different meaning given in this appendix?
The submission is that if a word partner is used in a subsequent provision within this appendix, and it is clear from the context in which that word is used that this definition does not apply, then this definition would not apply.
All right, so could you take us to an example in the appendix?
Well, the example obviously is the rule in question.
Right, so take us to it in the appendix.
Absolutely. Milady, I wonder if Milady would allow me to show the relevant rules in order rather than jumping to the rule in question and then coming back to the relevant rules. But I can...
If you can give me just one example, just so I've got it straight in my mind, then we'll come back to your...
Well, that is, yes.
specifically where we see a different meaning given or applied in the appendix?
So that is-
ELTRP
Yes,
2.2.3.
page 40 of the bundle.
Page 40.
Yes. You'll see the word partner right at the end of that page in Roman 3. And the submission which I will make very, very briefly is that the word partner, it is clear from the context in which that word is used that the definition, the general definition that you have in Gen 1.2 does not apply there.
Well, that's a submission you may have to make good. But so that's the one example you gave.
Yes.
You give, sorry. And there's no indication, apart from context, this is your submission, I think, that the context gives a different meaning of partner, but there's no explicit definition given.
No.
Thank you. Thank you for that. Go back to where you were. I'm sorry, Mr.
I'm
Zainab.
grateful. But given that my lady has asked this question, may I just respectfully take the quote back to Mahar, just to make one shot to show my ladies and my lord a couple of passages that are also relevant to the question that my lady has just
Yes,
raised.
please.
So Mahar is behind tab 6 of the bundle.
Yeah.
The issue before the Supreme Court in that case was about the construction of the maintenance provisions in the immigration rules. So if you look at page 260 of the bundle,
Yeah, got it.
right at the top of that page, you'll see the relevant rules. There will be adequate accommodation for the parties and dependents. So the issue before the Supreme Court was whether third-party support was available for the purpose of this rule. For instance, whether it was possible for a couple to rely on resources by a parent or friends. The courts below had held that third-party support was not available on proper construction of this particular rule. Now, if I may take my ladies and my lord then to page 267 of the bundle and ask the court respectfully to look against letter F. So there, Lord Brown gave an example of another provision in the immigration rules which expressly excludes third-party support, which says categorically that is able and willing to maintain and accommodate himself from his own resources. And Lord Brown made a point at paragraphs 27 to 28 that, well, if the Secretary of State had intended to exclude third-party support from the rules in question, this is the sort of language that she would have used. And ultimately, it was held that third-party support was not excluded for the purpose of the rule in question. So that was the reason why I felt it appropriate to take ladies and my lords not only to Gen 1.2 but also to Gen 1.4 to make the point that where the rules require express exclusion, the point that is troubling my lady, that is the sort of language that they use.
So it's paragraph 28, isn't it? Because 26 and 27, Lord Brown is indicating the respective arguments.
Yes.
And then in 28, he goes on to give his judgment.
Yes.
Could well have made that plain by using the same sort of language as in the part 6 and 7 cases. Okay.
You see the point. So there were rules where third-party support was expressly excluded.
Yeah, I see the point.
You see the point, yes.
We may have to put it into this context, but...
Absolutely.
Yes.
So I entirely agree that there isn't an express exclusion of the definition of word partner anywhere in this appendix. If there were an express exclusion, we wouldn't be here, of course.
But express definition beyond that which
No.
is in Gen 1.2
No.
rather than exclusion?
Yes, I mean, for example, a rule could have said, a subsequent rule could have said that, well, the definition in Gen 1.2 does not apply.
Yeah. So
As would be required to exclude the definition of word specified for the purpose of Gen 1.4.
yeah. But what we get in Gen 1.2 is unless a different meaning of partner applies
Yes.
elsewhere in the appendix. The point I was asking is there another definition given beyond Gen 1.2? And the answer is no.
The answer is no.
Yes.
Absolutely.
So Gen 1.2 envisages the possibility that partner will have a different meaning, you say.
That's
right?
the submission.
So
Yes.
that's the possibility raised by 1.2. My lady says, is there any express different meaning given anywhere? You say
The answer is no. Yes.
And so we search on your case for context, which
Yes.
must, you say, or does give rise to a different meaning of partner.
That's
So an example of a different meaning of partner applying, not stated, because it doesn't
Yes.
need to be, but to be inferred is your 2.3b3.
Yes.
And apologies if you've already answered this. Is there any other context within the rules that you can identify, not necessarily relevant directly to the facts here, but is there any other context where you would argue that a different meaning of partner applies within this appendix, or is it only 2.3?
No, there is another provision, and I'll take you to that.
All right, I'll be interested in that.
So that is at page 5 of the bundle. So you have seen Gen 1.2, 1.4. If I may now take the code to Gen 3.2. This is at page A5. You'll see a heading exceptional circumstances. So this rule is to address those who do not otherwise qualify under the provisions of Appendix FM, because the rules do address, if you look at Gen 3.1 B, for instance, Article 8 of the European Convention on Human Rights. So there may well be circumstances where Article 8 would require leave to be granted, even in a case where the couple have not lived together continuously for 2 years. I mean, let's assume that they've lived together for 1 year, 11 months, and 29 days. So one may ask the question, what's the difference? And then the relevant bit would be Gen 3.2. So if you look at Gen 3.21, so this concerns a person who does not otherwise meet the requirements of this appendix. For example, if that person does not meet the maintenance requirements, or they are not married to each other and they haven't lived together for 2 years. Subparagraph 2 tells us what should happen then. The decision maker must consider, on the basis of the information provided by the applicant, whether there are any exceptional circumstances which would render refusal of entry clearance, leave to remain, a breach of Article 8 of the European Convention on Human Rights, because such refusal would result in unjustifiably harsh consequences for the applicant, their partner. The word partner, the context tells us, is...
That's a better example
Yes. So
than the one you took us to first.
Yes.
Yeah.
So the context tells us that the word partner here would have a different meaning from the one given in Gen 1.2. Because, as I said, it's perfectly possible for a couple who haven't lived together for 2 years that the applicant in that sort of relationship is entitled to leave to remain by reference to Article 8 of the ECHR if the relevant rules are not met. So
it's perfectly possible for someone to be a partner for Article 8 purposes where they hadn't lived together for more than 2 years.
Absolutely. So although this rule does not expressly exclude the definition in Gen 1.2, it is clear from the context that the word partner has a different meaning. I also make a submission that it is possible for a person to apply for leave to remain as a partner even where the couple has not lived together for 2 years, and to qualify under Gen 3.2.2, because that relates to not only to the applicant but also to the partner. So Gen 3.2.
Terribly sorry, I didn't, my fault. I didn't understand that.
So assume we have a person who,
Mr. X
yes, who is
is here. He wants leave to remain,
he
lives with Y. Has done so for a year.
yes, that person can apply for leave to remain as a partner under Gen 3.2 subparagraph 2.
What do you mean? The partner can, as well as the first person.
No, the Mr. X would obviously apply because Y is a British citizen settled here already.
That's what I thought. I didn't quite understand what
So-
she's got. Assuming it's a she, what she's got to do with it.
What she, I mean, her rights are equally engaged, and in deciding whether to grant leave to remain to Mr. X, the Secretary of State will consider not only Mr. X's right to a family life, but also the effect of his removal.
Yeah. Well, obviously,
on
the
Mrs.
articulate
Life.
rights of everybody involved. are engaged.
Yes, but the submission, the ultimate submission is that it's possible for a person who has not lived together with a British citizen's partner for 2 years to apply under this appendix, under this particular rule.
Specifically. So they wouldn't wait for the decision maker to say, no, you don't apply as a partner because you haven't lived together for 2 years.
Absolutely.
It could go straight for the kill, as it were, in terms of saying, no, my application is made under Gen 3.2, subsection 2, because my my partnership is genuine, B, to refuse me leave would result in these consequences that impact not only upon me, but upon my erstwhile partner, my child, or whoever.
That is the point, and I do respectfully ask ladies and my lord to have regard to this point when looking at the rule in question, because as I shall explain in a minute, that is of particular relevance. Now, if you then go to page 12 of the bundle, you'll see a heading, requirements for limited leave to remain as a partner. And there is a long
I'm
list.
ever so sorry, Mr. Mallett, but before we go on, can we really divorce subparagraph 2 in the way that you say from the other application? Because it says subject to paragraph 4, and the answer may be provided by section BPILR or DVILR, I don't know, you'll be able to tell me, where an application for entry clearance or leave to enter or remain made under this appendix, or an application for leave to remain which is otherwise being considered under this appendix, does not otherwise meet the requirements of this appendix, the decision maker must consider whether the circumstances in subparagraph 2 apply, which seems to suggest that there's got to be an application that's being considered, or, a conventional application considered and rejected before this comes into effect, or have I got that wrong?
No, you've got it right. So there's got to be an application for leave to remain under this appendix.
1.2. Okay. So even if it's quite obvious that it's going to fail, you're saying that even if it's quite obvious that X knows that he's only been living together with Y for 1 year, he knows that it's a strong relationship, he wants to convey that. So he's got to go through the process of applying under the appendix first for leave to remain as a partner, knowing that he will not fulfil that criteria, in order to trigger this?
No, milady, the answer is this, that applicant will make a single application for leave to remain under this appendix.
Yes, but it can't be directly under 3.2.2. That's the thing I'm asking. There's got to be a hanger for it. So he's got to apply conventionally under
Yes.
the appendix, knowing that he will not succeed on the definition of partner, in order for the decision maker who says, no, you don't qualify, to go to 3.2 subsection 2. Is that right?
Yes, but subject only to this, that it's not the case that applicant will make a second application.
No, I
for
understand.
leave. Absolutely.
But he has to go through almost a farce, doesn't he? Knowing that he's not going to fulfil the requirements in order to trigger 3.2 subsection 2. Is that correct?
That is correct. Yes.
Thank you.
And
I'm very sorry to interrupt.
yes.
Is it necessarily, as my lady puts it, a farce? And
No.
this applicant applied under the family route, as I understand it, because he said, I'm a parent, and that's my family route.
Yes.
And the Secretary of State said, no, you fall under
This.
this provision, TRPT 2.3. And so we'll then go to the exceptional circumstances, which is how he's currently got his leave to remain.
That's how the system operates in practice. So it happens with some frequency that an applicant, for instance, would not meet the financial requirements, would not meet the immigration status requirement, but would put in an application for leave to remain. If that applicant says in that application at the outset that I don't meet the requirements
so you
of
can
this,
go straight to exceptional circumstances.
the Secretary of State will go to the exceptional circumstances straight away. It's not that the applicant would apply afresh. But wherein my Lord has put the point, in my respectful submission, in an entirely correct way, that the person would apply under this appendix, the Secretary of State considers that the requirements are not met, and then grants leave to remain under this particular rule.
And the objection, because it's what happened here, isn't it? The objection here is you only get you get leave, 5-year leave. Is that right? Under exceptional circumstances, not 10 years.
Well,
Don't worry.
yes. The answer. My learned friend perhaps is in a good position to answer this question as to what is it that Mr. Khattak seeks to achieve. But my understanding is that
something that's going through my mind.
Yes. So my learned friend will answer that question. But my understanding is that the objective is that if he stays on the partner route, he will qualify for indefinite leave to remain when he completes his 10 years in the UK.
Yeah.
But if he if he switches to the parent route, my understanding is that Mr. Khattak believes that he would be able to qualify for indefinite leave to remain after spending 5 years in the UK. But that isn't correct.
So he's better off where he is what you're saying?
Yes.
Sorry.
Yes. It makes no difference.
But in your case, he's better off.
Yes, it makes no difference. Practically it makes no difference. Mr. Khattak will not get indefinite leave to remain after 5 years. He will not. I will explain why when I'll show you the relevant rules.
Yeah.
But my learned friend, Mr. Khattak, takes the view that there is some notional benefit, and I'm prepared to accept for the purpose of this appeal that there is some notional benefit.
Mr. Malik, I'm sorry just to get
Not at all.
to
Not
my
at all. Yes.
point, please, because although my lord's reminded us what's happened in this case, I just want to be sure that your submission entertains the possibility that someone, X, not the appellant in this case, who's looking at a different set of circumstances, but X could say, I know that I will not fulfil the requirements of the appendix conventionally, but I will go down the Article 8 route, so I'm going to put the application in, but I've got to put it in knowing that the first part of the application will be
Yes.
knocked back
Yes.
because I want to trigger the Article 8 consideration.
Yes, but I do with respect, we wish to clarify this, that a grant of leave under subparagraph 2 is within Appendix FM. So subparagraph 1 says where an application for leave to remain is made under this appendix. So it's legitimate for an applicant.
It is.
Yes.
I'm not saying it's not, but I'm saying that there is a route open to people who will not meet the definition of a partner.
Yes, yes.
Yeah. And
Yes.
it is sometimes necessary for them to go through the first step of being knocked back in order to get this triggered.
I've no difficulty with that for the purpose of this speech.
That's all I was asking.
I'm very grateful. So you have my submission on Gen 3.22, even where the requirements in Gen 1.2 are not met, a person can qualify under Appendix FM under this provision. And that, in my respective submission, is key to this appeal. Now, if you then go to page 12, you'll see heading requirements for leave to remain as a partner. So there is a long list of requirements. If any of those requirements are not met, the applicant can still qualify under Gen 3.2, subparagraph 2 that I've just shown you. But for the purpose of the argument, may I simply highlight the financial requirements that appear at page 16. So in order to qualify as a partner, substantively not under Gen 3.2, one has to demonstrate that the gross annual income is £18,600, subject to certain exceptions and qualifications.
Sorry, can you tell me where we are again?
Yes, page 16 of the bundle.
16.
You'll see a heading financial requirements towards the end of that page.
I do, thank you.
So gross annual income of £18,600. So if a person, for instance, has £18,600 income, that person would qualify substantively under the rules as a partner, will get leave to remain, will get settlement after 5 years. But if that person does not have £18,600 of income, say he has £17,599, he would not meet this requirement, but he would say that, well, what difference a pound makes? It would be unjustifiably harsh to my partner to remove me, so grant me leave to remain under Gen 3.2. But you'll see you see the financial requirements. So that is the partner's route. And without seeking to complicate matters further, if I may just show my ladies and my lord, page 19 of this bundle, 19 and 20, you'll see a decision on application for limited leave to remain as a partner. And you'll see a reference to the grant of leave for 30 months and eligibility to apply for settlement after 60 months.
5 years.
Yes,
Yeah.
60 months. So 5 years. If all substantive requirements are met, the applicant gets leave to remain for 5 years, settlement after, leave to remain for 30 months, settlement after 5 years. But where the substantive requirements are not met, where, for instance, a person is not a partner as defined, the financial requirements are not met, then the next paragraph, DLTRP 1.2 applies. That is at page 20. And you'll see that in that case, the applicant would be eligible to apply for settlement after 120 months. So that's the main difference. So if you're not partner as defined, if you don't meet the financial requirements, you'll be given leave under Gen 3.2 for 30 months, but you won't be given settlement until 10 years. But if you meet substantive requirements, you'll get settlement after 5 years. So that is the general scheme. So that's the partner's route. If you then go to page 39 of the bundle. You have section R, LTRPT, requirements for limited leave to remain as a parent. So this is the parent's route.
Sorry, what page?
Page 39, my lord.
Right. I have to tell you, my page 39 has got decision on application for entry clearance.
Yes, so if you look at the next heading.
Oh, I see. Sorry, I do beg your
RLTRPT.
pardon. Yep. Beg your pardon.
So these are the requirements for leave to remain as a parent, not as a partner. And again, there is a long list of the requirements. And if I may take the quote first to page A41, just to show the financial requirements and to highlight how they differ from the partner route. So you'll see if you go to page 41, towards the end of that page, you'll see financial requirements, and you'll see that there isn't a minimum income threshold. All an applicant has to do is to provide evidence that they'll be able to adequately maintain and accommodate themselves and any dependents without recourse to public funds. That's not the test that applies to partner route. So parent route is flexible when it comes to meeting financial requirements. So I'm sure the court knows why I'm making this point. So if a person is a parent and also a partner, it would be easier for him to get leave to remain as a parent. And that is what the Secretary of State sought to avoid by formulating the rule that is in question. You have seen this provision. If I may take the court back to page A40, where you have the actual rule, the rule that is in issue.
This is the key point.
That's the point now. So I've explained the context, and now I'm now at the rule in question. You'll see relationship requirements. So these requirements must be met, and if you look at ELTRPT 2.3, that's the rule in question. So the applicant must have the sole parental responsibility of the child. That's not this case because the applicant does not have the sole parental responsibility. The alternative is subparagraph B. The parent or carer whom the child normally lives with, this is the appellant's, Mr. Khattak's former wife, must be, and then you have Roman 1 and 2, no issue about that. And then you have Roman 3. The applicant must not be eligible to apply for leave to remain as a partner under this appendix. So the point that the upper tribunal made, and the point that Miller and Friend makes, is that, well, the definition in Gen 1.2 is not expressly excluded. If you look at Roman 2, you'll see the words in brackets, which here includes a person who has been in a relationship with the applicant for less than 2 years prior to the date of the application. Miller and Friend says that, well, if the intention was to exclude the definition, the Secretary of State would have used the same words here. That's the key point that the upper tribunal made against the Secretary of State. The answer to that point is that those words were not necessary because Roman 3 refers to eligibility to apply for leave to remain under this appendix. And as I explained earlier, it is possible for a person to apply under this appendix even where the couple has not lived together for 2 years, because that person would apply for leave under Gen 3.2.
Well, they'd apply for leave not under Gen 3.2, but that would be considered. That's what the point is. That's why I was asking the questions.
Yes.
Someone having to make an application, hoping that Gen 3.2, subparagraph 2, would be their resource, because they know that they are not going to be eligible in terms of the definition that's given.
Yes, but they would be eligible to say that they qualify under Gen 3.2 subparagraph 2.
Yeah. So I know I'm a cracked record on this point, but Mr. Malik, just help me on this. So just suppose that we've got a slightly set of different circumstances than the one in this case. X knows that he's only got 12 months of the relationship under his belt. He knows that therefore he will be knocked back under Gen 1.2.
Yes.
But he is advised, well, don't worry about that because there are circumstances that we will ask the decision maker to take into account going to your Article 8 rights and the Article 8 rights of your partner and perhaps the Article 8 rights of other relatives. In the application, does that individual specifically say, I am not eligible under Gen 1.2, but I am eligible under 3.2 subparagraph 2? Or do they just have to, implicitly require the decision maker to go to that provision?
Yes.
Because this could frame eligibility.
Yes. The applicant is not required to expressly say that consider me under Gen 3.2 if from the information that is available to the Secretary of State, the Secretary of State takes the view that that person qualifies under Gen 3.22, the Secretary of State will consider.
Yes, I understand that. There's an obligation upon the decision maker. I understand that. But in the application, if the decision maker received a form which is very straightforward saying, look, I know I don't apply or I don't comply with the definition under 1.2, but this application is really subject to 3.2 subsection 2,
Yes.
which is part of the appendix. That's what your point is.
Yes.
Is it possible for them to do that? To absolutely
it is
nail
possible.
it on the head, effectively saying, don't bother with the first.
Absolutely.
I can take you straight away to what my issue is.
Absolutely. Absolutely.
Right. Okay.
Absolutely. No doubt about it. I mean, it happens, as I said, quite frequently that a person would be an overstayer, wouldn't meet the immigration status requirement, wouldn't meet the income threshold, for example, but they would still apply on Article 8 grounds. I'm sure that the court has seen examples of that.
Yes,
And they would
we've got to see the eligibility under this appendix.
Yes,
That's why I'm asking.
Yes,
So that's why I'm saying. So somebody who didn't meet the financial requirements, they could make a clean breast of that.
Yes.
In the application under this appendix.
That's the submission.
That's
yes.
what you're saying.
Yes.
Because of 3.2 subsection 2.
That's
it's the catch-all.
I now see the point, and the answer is yes. So
Yeah.
a person can say that, well, I don't meet substantive requirements, but I qualify as a partner under Gen 3.2.
Yeah.
That's possible. That is my submission.
And that's part of the appendix. That's what you're saying.
Yes. And if that is possible, then that person is eligible to apply for leave to remain as a partner.
But it's an odd use of the phrase eligible to apply when you're ineligible to apply, but your application gives rise, your ineligible application gives rise to an obligation on the Secretary of State to consider exceptional circumstances. I'm just wondering if that you are then eligible to apply for leave to remain for the meaning of, for the purpose of this subsection 2.
Yes.
You're not eligible to apply.
So you're
But your application will give rise to an obligation to consider amongst other things, partnerships, the Article 8 partnership point.
So you're obviously ineligible when it comes to the substantive requirements, and I've demonstrated by taking you to the relevant rules that the ineligibility means that you won't get indefinite leave to remain until you complete 10 years. But you are eligible to apply under this appendix generally based on Article 8.
Under 3.2, you're not applying at all. You may be making a submission, but by the way, you're going to have to consider 3.2, but you're not applying under 3.2. Because that's not the wording of 3.2.
But
It says where you has otherwise been considered, the decision maker must consider. So you're not applying under.
Yes. So,
or it could be said you're not applying under 3.2. You're applying under something else.
Lady, I see the point, and the way I'll seek to address this point is that if you look at Gen 3.21, the very first sentence, you'll see that the word appendix does not contain any qualifications. Where an application for entry, clearance, or leave to remain made under this appendix.
Mm-hmm.
Sorry, where are you now?
Sorry, page 5 again, Gen 3.2, the point that lady made. So where an application for entry, clearance, or leave to remain made under this appendix. So under this appendix is much wider than to say that you're not eligible for leave to remain under the substantive requirements of this appendix, for example. Under this appendix, in my respective submission, includes the next paragraph.
So you say
Article
that
Wait a minute, Mr. Malik. I mean, you've got to read the whole sentence, haven't you?
Yes.
Where the application made under this appendix does not otherwise meet the requirements of this appendix, then you can seek to take advantage of your Article 8 rights.
Yes, but you'll see also a reference to Part 9 of the immigration rules. So Part 9 are the general grounds of refusal. For instance, if you have a criminal conviction or you've used
fraudulent documents,
deception,
so
and so on and so forth. So you say that you apply under this appendix, but you're disqualified because you don't meet the substantive requirements, or you've done something that you shouldn't have done. Even in that context, you will qualify. You may qualify under Gen 3.2. So that is the first submission that I make, which is that even where a person does not meet the financial requirements, the relationship requirements, he is still eligible to apply under this appendix. And
because of 3.2.
Yes, and for the purpose of that rule, and the fact that there is no express exclusion is unremarkable. It makes no difference because of the difference in Gen 1.2 and 1.2 and 1.4. So express exclusion is not required.
Can we just look for a moment at the interrelationship between, and I'm back onto ELTRPT 2.3. So this is page 40, Mr. Malik.
Yes.
Between 2 and 3.
Yes.
So the parent or carer with whom the child normally lives must be a British citizen in the UK or settled in the UK, fine. Not the partner of the applicant, which here includes a person who has been in a relationship with the applicant for less than 2 years prior to the date of the application. So that's quite clear. So this appellant cannot apply in relation to the child that he has with his partner,
Yes.
his present partner,
Yes.
and the applicant must not be eligible to apply for leave to remain as a partner. So why is it then that subsection 3 is necessary at all? Because if the parent or carer with whom the child normally lives must be not the partner, what is the purpose of subsection 3? Is it in relation to a completely different person? Because it seems to be conjunctive.
Yes. Well, if, for example, the applicant Mr. Khattak were still married to his former wife,
Yeah.
then he would fail under Roman 2.
Yes.
And that is what Roman 2 is that is a sort of case for which Roman 2 in my submission is.
But why is
designed
it
for.
conjunctive and rather than or?
Because there can be a situation where a person would not fall for refusal under Roman 2, but can fall for refusal under Roman 3.
But does it not in fact mean that the definition of partner in B3 must be the definition of partner in Gen 1.2? So they're actually positively distinguishing between the less than 2 year type partner,
Yes.
on the one hand, and the more than 2 year partner on the other.
Yes. Of course, I see the point. And that is
That's
the
the point
principle.
against you.
That is the principal point against me, and that is the reason why I make the submission that I've just made, that express exclusion is not required. I of course completely recognize that this is the point against me, and if the words in brackets had also appeared in Roman 3, that would have left no doubt as to what the Secretary of State meant. But the submission is that express exclusion was not required because a person who does not meet the definitional requirement can still apply under Appendix FM for the reasons that I've given. So that is the submission. Now, if the court applies the autonomous definition in Gen 1.2 to this particular provision, that, in my respectful submission, would be inconsistent with its purpose and can lead to abuse. And
Which abuse is that?
yes. So one has to, in my respectful submission, know the purpose of this provision before considering how that purpose can be abused. Now, the purpose of this provision, in my respectful submission, is twofold. First, it is to ensure that the applicants apply in the correct category and to avoid or minimize the possibility that an applicant would circumvent the financial requirements. And the second objective is to avoid placing the decision makers in a position where they would have to guess the applicant's true intentions. So I've given the example that.
Can I just get that second point down? To avoid the decision makers
being placed in a position where they would have to guess what may or may not be the intention of an application. So take the example.
Well, do they have to guess the intention? Because whether it's one thing or another, it's in order to get leave to remain.
Yes. So a person has a child.
Yeah.
And also a partner.
Yeah. You're just saying they can't choose. It's the strictest route that applies.
Yes.
Yeah.
So that is the purpose. So let's assume that there's a person who has a partner and a child. To qualify as a partner substantively and to get settlement after 5 years, that person must meet the financial requirements. Now that person, when making the application for leave to remain to the Secretary of State, can simply conceal the fact that there is a partner and rely solely on the child to circumvent the financial requirements.
Yes.
And that person will get leave to remain as a parent and settlement after 5 years. So if one reads the rule in question in the way the upper tribunal has read, then that, in my respectful submission, would not be consistent with the purpose that I've just identified and can lead to abuse. I've given the example at paragraph 32 of my skeleton argument. The upper tribunal said that, well, there won't be a real possibility of abuse, because even to qualify as a parent, the applicant would need to meet the financial requirements. But the answer to that point, as I explained, is that the financial requirements that apply to partners are much more stringent than the financial requirements that apply to parents. So in my respectful submission, if there are two possible alternative constructions available to this court should opt for a construction that is consistent with the purpose of this rule and that avoids or minimizes the possibility of abuse.
And you can only refer to it as abuse if we accept your interpretation of ELTRPT 2.3b. Because otherwise, it's possible for someone to say, well, in the same way as they go about managing their tax affairs, I'm not committing any offence, I'm abiding by the spirit of the appendix, and as night follows day, if there's an easier way of getting what I want, I'm going to take it.
Yes, and the submission, of course, is that this rule is designed
to prevent that.
To prevent the easier way. That's the submission, and that's why I took the court to Mahad.
Yes.
Of course, you look not only at the language that is used, the fact that Roman 2 is different from Roman 3, there is no express exclusion. But you also look at the context, you look at the scheme as a whole to decide what the Secretary of State must have intended.
Must have intended, you say.
When she made this.
No, forgive me.
What the Secretary of State must have intended in formulating this rule. So the ultimate submission is that if two possible constructions are available to the court, and I entirely accept that the construction that the upper tribunal has put forward is a plausible construction. But the submission is that where there are two alternative plausible constructions, the court should opt for a construction that is consistent with the purpose of the rule and avoid or minimizes the possibility of abuse.
Why must the Secretary of State have intended this construction? Just help me with why it's so obvious.
Because if that is not the purpose of Roman 3, then what is the purpose, one wonders? That is the only reason why we have this provision, to ensure that if the applicant is in a partner relationship, that person is not able to circumvent the financial requirements to qualify as a parent. That is the only obvious purpose of this provision.
Yeah, so if you're in a relationship with somebody, you're a partner, and you would expect to get leave to remain as a partner because you've been together for 2 years or more, then you've got to go down that route because then you've got to satisfy the financial requirements, etc.
Yes.
But why does it mean any more than that? Why does it mean you only have to have been with somebody for 6 months?
Well, because even in I mean, of course, any construction that this court would give to this rule would apply not only to one category, but of course across the board. And the submission is that it would give choice to the applicants as to what to do with the applications. They can opt to apply as a parent. They can conceal the partnership relationship, or can say that relationship no longer exists, get leave to remain as as a parent and qualify for settlement after 5 years.
Obviously, applicants could do all kinds of things. I mean, they could, let me take an example that you and I have some vague familiarity with. They could construct completely bogus bank documents to
Yes.
support their argument about financial
Yes.
material and what they've got available to them.
Yes.
I mean, there are all kinds of things that applicants could do.
And yes, and the submission, of course, is that the Secretary of State tries her best to formulate the rules to address possible abuses. And in a case of submission of bogus documents, the Secretary of State has Part 9 suitability requirements. In a case of this sort, this is the purpose of the rule.
Can an applicant via other routes, is it right that applicants have no choice elsewhere to decide which route they go down? I mean, is this concept that it really, the policy is that applicants cannot choose which route to go under, is that of universal application?
No, that is no, that is not of universal application as such, but is not of universal application as such, but that is of application for the purpose of this appendix. I mean, of course, a person can apply as a student, and not as an entrepreneur. So that person, of course, has a choice. But when it comes to seeking leave to remain and settlement on the basis of the family life, the intention is to ensure that as many people as possible meet the minimum income threshold. And that is the reason why we have this rule, to ensure that if someone is in a partnership relationship, it is under that category that person applies and is given leave to remain, as opposed to as a parent leading to settlement after 5 years.
So within this context, no choice.
No choice. Yes, that is.
So the whole Appendix FM, no choice.
Well, the way I will put my submission is that the rules are designed to ensure that there is either no choice or to minimize the element of choice. And it's not simply, the objective is not only to minimize the element of choice, it's also to ensure, as I submitted, consistency and to make things easier for the decision makers.
Can you explain this to me? I mean, in a situation where there is no eligibility in terms of meeting the requirements of 1.2,
Yes.
what you're saying is that the whole purpose is to make it easier for the decision makers. But isn't it difficult for the decision makers then to contemplate 3.2 subsection 2 on the basis that they have got to make an evaluation of the quality, the genuineness of the relationship? Because it isn't defined by its temporal existence.
Yes.
It's defined by some other quality. Now, in normal circumstances, if there was no child to be considered, then the only prospect would be the partner route.
Yes.
But where there is a child, why is it not appropriate for the appellant to say, well, look, I can understand why the Secretary of State specifies the temporal nature of a relationship to give some indication of its longevity, its genuine nature. And therefore, I'm not going to trouble the decision maker with that. I don't need to, because I can point specifically, and in this case, I can point specifically to my child with a previous partner with whom I am not living. I've got no intention of rejoining, and therefore all that the decision maker has got to do is to say, well, have you got the means to support yourself? I mean, it's not really making the decision maker's life any easier by giving them this flexibility, is it?
I mean, of course, if that person's relationship with the former partner has ended, no problem at all. But
Well, no, No, there isn't. But it's when we've got the situation here where if it was just that situation, the appellant in this case could come forward and say, I can fulfil
Yes.
1, 2 and 3.
Absolutely.
Now, what's happened is that he applied as a parent, and somebody says, just hang on a second, although you've not applied as a partner, and although you don't fulfil the criteria under 1.2, actually, we think we're in possession of enough material to say that your partnership is genuine, and therefore that Article 8 considerations will arise.
Yes.
Because 3.2 subsection 2 could only apply if there's the initial adjudication, well, this is a genuine relationship. Do you agree?
Yes.
Okay. So the decision maker has got to have the information before them to adjudicate that the relationship is not a sham.
Yes.
Okay. Now, you did say that this would make it all easier. This makes it easier for the decision maker, but that's the point of the question. You're calling for the decision maker to make an evaluation outside the definition.
Yes, and the submission is that is what the Secretary of State intended her policy
To be.
to be, because she wants to ensure that if someone is in a partnership relationship of any length, that person, before he is given leave to remain, in principle should meet all the requirements, including the financial requirements. But if for some reason those requirements are not met, you then come to the evaluative exercise. That's what the Secretary of State intended her policy to be. And you have my submission that my proposed construction is more consistent with the purpose of this rule and prevent or minimizes the possibility of abuse. So if I may just now move to my final point.
Yes.
Which is that if one applies the autonomous definition in Gen 1.2 to this rule, and on the upper tribunal's construction leads to some odd consequences. And that is another reason why the court should prefer an interpretation that avoids those odd consequences. Now, the first odd consequence is that on the upper tribunal's analysis, a person who does not meet the definition in Gen 1.2 has the benefit of applying under the parent route with modest financial requirements. But an applicant who does meet the requirement due to a stronger partner relationship for at least 2 years, they must seek to qualify under the stricter partner route with robust financial requirements. So there would be an inverse relationship between the strength of the appellant's partnership relationship and the ability to obtain leave to remain. So it effectively places a person with stronger partnership relationship in a less favorable position.
Well, how can you say that? Because if they're applying as a parent, I mean, it's the strength of the parental bond that's being relied upon, not the strength of the partner's bond.
Yes.
And therefore, is that a fair or an appropriate comparison, Mr. Malik? Because if you've got someone who's been in a partnership of 2 years plus and happens to have a child, it could be that the nature of the relationship with the child is far more important than the nature of the relationship with the partner, which may be 2 years or 3 years or more, but may be distinctly rocky.
Yes.
And I think this is the point made by Mr. Bilal Malik, that it's not just a simple apples and apples comparison, it's apples and pears. So the very point you've made, I can see logically, but that is to surely dilute the principle that the Secretary of State obviously by looking at the family route, which includes the parent route, places emphasis and importance upon genuine relationships with a child.
Yes, but what I invite Milady to consider with respect is that why would the Secretary of State had intended for a scheme which places those with a partnership relationship that is not sufficiently strong in a more favorable,
Because
more
they may have a
favorable position.
child with another partner, as in this case, which is particularly strong, and therefore it would be permissible, for example, for someone in this appellant situation to come to the Secretary of State and say, look, I do hope my relationship with my new partner is going to subsist, but I can't be sure because it's early days. But I can tell you that I have ongoing contact with my 5-year-old daughter, and my relationship with her is incredibly strong. And the one thing I do know is that I do ask for permission to remain in this country because it is such an important relationship. It cannot be, as it were, driven apart.
Yes.
So, I mean, in those circumstances, the Secretary of State would have a rightful interest, surely, in ensuring that that parental bond may take precedence over a, as yet, undefined, by virtue of 1.2, partner relationship.
Yes. No, I see the point, but if Milady would compare that case with a case where the relationship is the partner relationship is much stronger
Yeah.
over 2 years,
Yeah.
say, then that person would be treated less favorably in the sense that that
No,
person
they
would then have
wouldn't,
to make
because
financial
they'd
requirements.
be eligible to apply as a partner then.
Yes.
There's no two ways about it.
No.
Wherever that
Yes.
interpretation construction falls, they would be eligible to apply as a partner.
The submission is that the Secretary of State could not have intended for an outcome, for this outcome where the stronger a person's partner relationship, the more difficult it gets for that person to get settlement.
Okay, so that's your
You mean
first
because of the
example.
financial?
Because of the financial requirements, yes, and the route. And then you consider that in the context, and if I may then take the court to the one final provision in this appendix, and that is at page 44 of the bundle.
Thank you.
So this is for settlement. So a person qualifies when a parent would qualify for indefinite leave to remain.
Yeah. Section EILRPT.
Yes.
Yeah.
So take the example of a person who is just shy of meeting the definition in Gen 1.2. The relationship, say, is for 1 year and 11 months. That person applies for leave as a partner, is given leave to remain as a parent. But after a month, that person would be eligible to apply as a parent, as a partner, because after a month, the partnership relationship would be of 2 years duration. So take this example of this case. The relationship, they started living together in December 2017. And the application was made in June 2019. And Milan Friend says, the upper tribunal says that they were not eligible to apply as a partner then. But surely, even on the upper tribunal's construction, Mr. Khattak became eligible to apply as a partner in December 2019 because they completed 2 years together as a couple then. So what happens next? When Mr. Khattak would apply for indefinite leave to remain, he will face a problem. And anyone in his situation would face a problem. Firstly, see subparagraph 1a. So in order to qualify for indefinite leave to remain, in respect of the application falling within subsection 1a above, the applicant must meet all the requirements of section ELTRPT, eligibility for leave to remain as a parent. And 1a is where a person applies for indefinite leave to remain on completion of 5 years. Now, this requirement, of course, includes the requirement that we have...
This may be important, and I've just missed you. So, sorry, 1.1, to meet the eligibility requirements for indefinite leave to remain as a parent, all of the requirements of 1.2 to 1.5 must be met.
Yes, and the relevant requirement is in 1a first.
1a?
Yes.
1.3, 1a.
No, sorry, one capital A.
Oh, I'm sorry.
At the
There we go,
bottom,
got it.
yes.
Thank you. Right, in
So
respect...
the applicant will qualify for indefinite leave to remain only if the applicant meets all requirements in ELTRPT, eligibility for leave to remain as a parent. So when Mr. Khattak applies for indefinite leave to remain, even if the upper tribunal is right and if this court upholds the upper tribunal's decision, he will face an insurmountable difficulty. The Secretary of State will say that, well, you, irrespective of what happened in June 2019.
Even if that was right, it doesn't help you to get settlement.
Yes. So,
And you say that's what an absurd inconsistency.
yes, so why would the Secretary of State intend for a policy that is so unprincipled?
Did you argue that below? I can't find it. And I'm not criticising you. I'm simply asking to see how the judge dealt with it. Because he certainly deals with the choice point at paragraph 37, page
Yes.
52.
And the abuse point was dealt with. Well, I'll save my lady's time by being candid and to say that this isn't a point that was expressly made to the upper tribunal, although the abuse point was made. This particular consequences was highlighted.
I'm
Yes.
simply making at this
No,
stage
yes.
a point of general inquiry.
Yes. So it was only after looking at the upper tribunal's decision that the policy client identified
So
further inconsistency.
Would Mr Khattak be better off, not necessarily the relevant test, would he be better off under the partner route?
It makes no difference, I would say, because whether he's under the partner route or the parent route, he would qualify for indefinite leave to remain on completion of his 120 months.
Not under this rule. Your point is he wants limited leave to remain as a parent.
Yes.
But he won't get settlement.
No.
As a parent, and you say that can't be right. You've got to look at the scheme as a whole.
Yes. Yes.
And look for internal consistency.
Yes.
So would he, if he had got limited leave to remain, if he had applied for limited leave to remain as a partner, he has to meet the additional financial requirements. Where does it leave him on settlement?
Well, lady, he arrived in the UK on 14th of January 2015, and he would complete his 10 years in the UK on 14th of January 2025. And there is another rule that this court may or may not be familiar with, which says that if a person resides in the UK continuously, lawfully for 10 years, that person gets indefinite leave to remain.
Right.
So in that rule will be available to this particular appellant in 2025. It makes no material difference. But
could it make a difference?
Yes, in a different case.
In
yes.
a different case, it could make a difference.
Absolutely. Yes.
So going then to EILRPT 1.1, which provides that the requirements of 1.2 to 1.5 must be met. The applicant must be in the UK with valid leave to remain as a parent under this appendix, and that's what he applied for. That's what the appellant applied for.
Yes.
The applicant must, at the date of the application, so that's at the date of the application for indefinite leave to remain as a parent, have completed a continuous period of either at least 60 months in the UK with leave to enter, granted on the basis of entry clearance as a parent, or
Yes.
limited leave to remain as a parent granted under paragraph D LTRPT 1.1
Yes.
or a combination.
This case.
Why wouldn't this appellant, having made his application and getting his limited leave, not in 60 months, be entitled to apply?
Well, because
There's
that,
1A.
yes, of course, he'll be eligible to apply because he has completed his 60 months in the UK. But that 60 months in the UK as a parent, if he gets leave to remain as a parent, he'll complete 5 years, then apply for settlement. But then he'll face the difficulty in 1A, that the Secretary of State, the position would be that the Secretary of State would say that, well, when you got leave as a parent, you were not eligible to apply as a partner because the partnership relationship was less than 2 years.
But he's not, but if he's got leave to remain as a parent,
Yes.
and he's done the 60 months, what is it that in 1A that says that he can't make an application for indefinite leave to remain because he will have met all of the requirements, that is eligibility for leave to remain as a parent, at the time he got the limited leave?
The answer is in 1.1, ILR PT 1.1. So to meet the eligibility requirements for indefinite leave to remain, all of these requirements from 1 to 5 should be met. So the fact that a person meets 1.3 is not enough. So firstly, he has to have 5 years residence as a parent, but then that's not enough. You then go to 1A. And if, when you apply for indefinite leave to remain, you are eligible to apply as a partner.
You're not a parent. You're not eligible for leave to remain as a
For
parent.
indefinite leave, exactly.
No,
but
I don't see that. I'm sorry,
no,
Mr. Malik. I'm sure it's me, but I just don't see it from the plain use of the language there.
okay. Lady,
If you've got limited leave to remain as a parent, you bank that, as
Yes.
it were, and then you go and you say, the date of my application for indefinite leave to remain is because I have completed at least 60 months in the UK with that limited leave.
yes.
So you then say, well, in respect of an application falling within subparagraph 1A above, and 1A is at least 60 months in the UK.
Yes.
Yeah, so why can you not then fulfill the requirements?
Yes, because you would meet the requirement in 1A for sure because you have been here for 60 months.
Yeah.
But you won't meet the requirement in 1 capital A because to meet that requirement, you must meet all the requirements in ELTRPT. So if
this, what we're looking at. on
what we
page
looked at
44.
a minute ago. So if
Oh, sorry. Oh, I see.
no, it's
It's L, not I.
Right. So where do we go to have a look at this?
well back to the rule that we have been looking at.
Back to 2.3b2.
Absolutely. So at page 40.
Page 40.
Yes. So the rule that we've been looking at.
So this is a bit circular, isn't it?
Yeah. See. Yes. So to qualify for indefinite leave to remain, you should not only meet the 5 years requirement, but you should also again meet the eligibility requirements, the
So
requirements that we have been looking
That
at.
means that somebody who has a child cannot effectively enter into a lasting relationship which would otherwise entitle them to apply as a partner under this appendix at any time during that child's minority. That's what it amounts to.
Of
Because
course,
they would consistently be met with the,
Yes.
I'm sorry, no matter how long you've been here you've been here now for 60 months in the UK with limited leave to remain as a parent. We know that there's been
Yes.
nothing wrong with that at all. But we do happen to know now that subsequently you met
Yes.
2 years ago or 18 months ago
Yes.
a new partner,
Yes.
everything's going swimmingly, but that means that the clock stops and all bets are off. That's what it amounts to.
Yes. So, of course, I'll not put it in this way. I will not say that the applicant is not allowed to enter into a partnership relationship, but I will say that if the applicant enters into a partnership relationship, then parent route would not be available to the applicant.
At any stage?
At any stage.
So-
Yes. So that person would then apply for under the partner route.
But isn't that policy undermining any idea of a stable family life, which may be for the benefit of a child, maybe for the benefit of other children? I mean, is that really the policy of the Secretary of State?
Yes, it is, because, of course, with the entirely legitimate aim to protect the welfare of a child, the Secretary of State also seeks to ensure that those who are in a partnership relationship, in principle, should meet the minimum income threshold requirements before they get indefinite leave to remain or settlement, unless there are exceptional circumstances, as contemplated in Gen 3.2. So the answer is that this is in my respect submission plainly what the Secretary.
So the answer is, for any parent considering this, that for the next 5 years, after having achieved limited leave to remain as a parent, do not enter into any relationship, because if you do, then the clock will stop running and you will never gain indefinite leave to remain as a parent, regardless of how strong that relationship may subsequently transpire to be.
Well,
that's the effect.
Cruel as it may sound, that is the policy.
All right.
That is the policy.
All right.
And the parent, or the father or mother, can get settlement status as a partner.
Of course.
If those financial requirements are met.
Absolutely. So if financial requirements are met, you get leave to remain as a partner. So the scheme is to ensure that those who are in a partnership relationship meet the financial requirements. If they don't, then they have to demonstrate that there are some exceptional circumstances before they qualify. And to answer the point that Lady Justice Carr made, not this case, because Mr. Khattak would complete 10 years in any event. If this court adopts the upper tribunal's interpretation, it may actually place the applicants in a difficult position, because a person on a partner route, as Lady Justice Carr pointed out, may well be better off and may get indefinite leave to remain after 5 years.
Well, they might do. There's lots of speculation about that.
No.
But on the basis of this interpretation that you propound, it could mean that someone who would otherwise have carried on with the application for indefinite leave to remain as a parent is derailed from that route by virtue of them entering into a partnership, and they then fall between two stools, so that any relationship that's been built up for the last 5 years with a child may come to nothing if the applicant then falls between two stools because he's got no partner to rely on in order to make an application as a partner.
Lady, that is the scheme. That is the effect. That is the scheme. And if Mr. Khattak hadn't entered into a relationship with Mrs. Begum, he would have qualified for leave to remain as a parent. And settlement
if
after.
the relationship breaks down, then you meet the requirements for settlement that we're looking at.
Yes.
So is it right that you fall between two stools?
If the relationship with Miss Begum ends,
Yes.
then Mr. Khattak would be entitled to leave to remain as a parent again. So the idea is
leave to remain.
sorry.
Limited, because it would have to start again. The 60 months would have to start again.
Well,
He couldn't finish the relationship with Mrs. Begum
Yes,
and then
yes,
say,
yes,
but
absolutely.
I'd had 48 months.
no, you're absolutely right. So
Got to start again.
absolutely leave to remain had to be as defined as a parent as opposed to a partner. but that is the effect. So the submission that I invite the question that I invite Milady and Milords to consider is why the Secretary of State would intend for a policy to grant Mr. Khattak limited leave to remain, simply to deny him indefinite leave to remain a few months thereafter. That is not.
Well, that's why I'm wondering at the interpretation that you're placing on 1A, actually, because I can't see that she would want to.
That she would want to grant indefinite leave to remain.
No, that she would want to refuse indefinite leave to remain if otherwise the appellant had been in limited leave status for at least 60 months.
Yes, so.
And then just because he then becomes eligible as a partner, that all comes to an end, and I do think he falls between two stools. He then has to make another application to apply as a parent.
Not this case, but I can think of an argument that 1.31 small a refers to 60 months in the UK with limited leave to remain, not 60 months continuously in the UK with limited leave to remain. It may be possible. Again, not this case. I'm not putting forward.
You understand, Mr. Knight.
Yes.
The only reason I make these questions is to actually understand better your argument.
Yes.
Yeah. Okay.
This is probably not a helpful question, but is it possible? Is it possible for an application? I'm looking at page 44. An application falling within subparagraph 1A. Is it possible for the applicant not to have met all of the requirements of section ELTRPT at the time of the earlier leave or limited leave being granted? Do you see what I mean? I'm just wondering whether the applicant must meet actually means must have met.
No. I mean,
that doesn't work.
No, surely must meet all the requirements. Means must meet all the requirements now.
Okay.
Otherwise, the provision wouldn't make sense because you wouldn't be given, you wouldn't have 5 years unless you had met those requirements.
Right. And then the second question is, I can't find the eligibility for indefinite leave to remain as a partner section.
Yes. So that.
Can you just help me with that?
Yes, lady. Yes. So I've shown you 1A. Just for completeness, if you also look at 1B, it's not relevant to this appeal, but it relates to a case that falls within B. So even if a person resides in the UK for 10 years as a parent, that person would still have to meet the requirements in the eligibility requirements. So whether it's 5 years or 10 years makes no difference.
So where do we get that from?
It's 1B, 1 capital B at page 44. Yes. So this is the next.
Must meet all the requirements of.
Again, all eligibility requirements.
Why does 1A say just the requirements of section E/LTRPT, all of them?
Yes.
And 1B, 1 capital B little a, only refer to 2.2 to 2.4.
Yes, because those are the immigration 2.4.
Certainly, and on either basis, the relevant ones included. I understand that.
Yes, there's a reason for that. That is 3.1, 3.2. Yes, that is. You'll see that financial requirements are excluded.
I see.
So financial requirements are in 4.1. So that is excluded. So if you don't meet financial requirements, you have to live here for 10 years before you qualify for settlement. So this is to ensure that, well, even if the financial requirements are not met, a person gets indefinite leave to remain after 10 years, okay, as long as he's not eligible to apply as a partner.
And then the partner,
yes,
eligibility for indefinite leave?
Page 22 of the bundle.
Thank you.
It's EILR RP 1.1. So these are eligibility requirements for indefinite leave to remain. There's a long list of requirements, but in short, you'll see from page A23, page 23, that there is a 5 years route, just like parents' route, and a 10 years route.
And we get the same one capital A. In
yes.
respect of an application, the
Yes.
applicant must meet all of the requirements of eligibility for leave to remain as a partner.
Yes. So if you meet the financial requirements, you'll get settlement after 5 years. If you don't meet the financial requirements, then you get indefinite leave to remain after 10 years.
Same scheme.
Same scheme, yes. And the scheme is logical.
Why is this in a different place? It's because I just need to get my structure right. This is section. Right. Okay.
So this comes immediately after. So the way in which the appendix is structured, it's page one of the bundle. You'll see the general structure. So the family life with a partner is being dealt with first. Then there are certain other categories, and then family life as a parent.
All right. So family life with a partner comes top, and then family life as a parent comes later down. I see.
Yes.
Thank you very much.
So just to bring the argument to conclusion, of course, the point against me is that there isn't an express exclusion as in Roman 2, and it is entirely appropriate for the court to take that into account and to ask itself, well, why the Secretary of State has not expressly excluded this. That is a point against me. But then, as I have sought to demonstrate, if my proposed construction is consistent with the objective of this provision, it minimizes or avoids the possibility of abuse, it is coherent, and it makes sense. And for these reasons, I invite the court to allow this appeal by adopting my proposed construction. I haven't taken you to the upper tribunal's decision, but the question for my ladies and law is a question of law. So if the court agrees with my proposed construction, the court will obviously conclude that the upper tribunal's decision was wrong. But in my submissions, I have addressed the reasons that were given by the upper tribunal for its decision. So unless I can assist you any further, these are my submissions.
Just two things. First, what we were looking at a very short time ago, page 44, 1 capital A. Have I understood this correctly? That means that if you're applying for indefinite leave to remain because you've been a parent, you've had parent leave for 60 months, you must, at that time, namely when you're applying for indefinite leave to remain, meet all the requirements in E-LTRPT.
Absolutely. Absolutely.
So if back, however long ago it was, 3 or 4 years ago, you got your limited leave as a parent, perfectly legitimately. I mean, the child was living with a British citizen. She wasn't your partner, and you, as a matter of fact, had no relationship at all then. So, perfectly appropriate application and granted. If 3 or 4 years later, you're now in a partnership relationship with somebody, and indeed full, so never mind what Roman numeral 3 means.
Yes.
Even on the 2-year, you're now in a partnership relationship. So you now don't meet the requirements.
Absolutely. That is the effect of this provision.
So even if you're right in terms of little 3, but the facts are that there's no partnership, so it's perfectly appropriate to go down the parent route. If by the time you come to apply for indefinite leave, you are in a partnership relationship, then you won't get indefinite leave to remain as a parent because you're now in a partnership relationship.
Yes.
Well, that
Yes.
point my Lord raises suggests that there isn't a carry across from grant of limited leave to remain as a parent to indefinite leave, and it's not a single system because the chain could be broken at any stage, doesn't it? I was putting to you, we must surely see this as a whole, that actually that demonstrates I'm not right. No doubt not for the first time, but there is no link that there is no, or on the face of it, objective which says, well, if you get limited leave to remain as a parent, there is somehow a presumption that you will get indefinite leave to remain on the same basis.
I mean, as I understand it, that's right.
That is right. Yes, but
I mean, you, in your skeleton argument, you developed it already. Have said, well, here's what orally called an odd consequence, in writing an absurd consequence. But it is actually a consequence of the rules, isn't it? And you can start as a parent perfectly legitimately. By the time you get to the point where you want indefinite leave, you can find yourself, oh no, you now must be a partner.
Absolutely, but I'm not sure if it undermines the argument that I've put forward, because the submission is that if you were already in a relationship, partner relationship, when you applied for limited leave to remain, then you want.
That begs the question as to what little 3 means, doesn't it?
Well, yes, and then you won't qualify. The submission is that why would the Secretary of State grant limited leave as a parent to someone who is in a partner relationship, simply to deny that person indefinite leave to remain on that basis a few months down the line, as is the case here.
I think we've got your submissions on that. And the second point,
Tab 18 of the bundle, the last document, is the application that the respondent made, as I understand it.
Yes.
And this presumably is self-evidently, it's a form provided by the Secretary of State, and it's filled in by people in accordance with whatever their particular circumstances are.
Yes.
And it says at the top, type of application, family route.
Yes.
Which is obviously generic.
Yes.
And the way in which it's identified that this is, the person wants to follow the parent route is, have I got this right on the first page, what's the relation to the person you're applying to remain with in the UK?
Yes.
And it says parent.
Yes.
can you help me where we are with this?
First page.
Yeah.
So at the top,
yes,
type
I've
of
got it. Sorry.
application,
Yes,
family
sorry.
route,
Thank
and about
you.
two-thirds of the way. So if I, for instance, said I didn't have a child, but I did have a partner, then I'd type partner there rather
Yes.
than parent.
Yes. Yes, that is correct. Yes.
Right. And that's the way in which you tell the Secretary of State what route you want to follow.
Yes.
All right.
And within this application, Mr. Khattak also referred to his partner relationship with Mrs. Begum.
Yes.
And that's how the Secretary of State picked the point that he's
Yes.
eligible to apply as a partner as well.
Well, if we go to the bottom, the bold type is page 18. I think it's the fourth page.
Yes.
There's detailing the relationship. And the Secretary of State asks, have you lived with your partner continuously for 2 years?
Yes.
And the answer is no.
Yes.
Presumably, if the relationship on which the applicant was seeking to rely was partner, and he was an assiduous reader of the rules, then he would hope to put yes there.
Yes, but
that would be the basis upon which he'd be applying.
Yes, but see, of course, the next question for completeness as well.
Oh yes, so he's set out the position. I mean,
Yes.
he's provided very large amounts of information.
Yes.
Doubtless, because he had very much in mind Gen 3.1.
He did not apply for leave as a partner. Of course, I accept that.
Yeah.
But the question is whether he was eligible to apply as a
Right.
partner, and that is the question that ladies and lords will grapple with.
All right, thank you very much.
I haven't taken ladies and lords to the policy document for the reasons that I've given. That I cannot rely on the policy document to invite the court to construe the rule more rigorously. But you have the policy documents in the bundle. I can, rather than taking you to that, just for completeness, give you the page reference numbers. So behind tab 4, see page 80, and behind tab 3, see page 89. So what I submitted is the correct construction of the rules is consistent with the Secretary of State's published policy. I'm very grateful.
Anything
No, thank you.
Thank you very much, Mr. Malik, indeed. Thank you. So, Mr. Lal Malik.
My lady, I propose to just follow broadly the structure of my skeleton, and then, with your permission, at the end, just so to speak, mop up a couple of points made by my old friend, which do not.
Absolutely. Do take it. We have read your skeleton, Mr. Bilal, but of course we are happy for you to take it in that order.
Well, my lady, the first 11 paragraphs of my skeleton, I think, probably are relatively uncontroversial. They simply set out the background and the factual matrix, which is more or less agreed.
Yes.
Paragraph 11 itself sets out the controversy, and I agree more or less with my learned friend as to what that controversy is, though I articulate it slightly differently. Where I would begin is with the phrase eligible to apply itself. That phrase in my submission has to be read conjunctively with the word partner. So an applicant, for the purposes of ELTRPT 2.3 Roman 3, must not be eligible to apply as a partner. And those words, eligible to apply and partner, have to be read conjunctively, because if we separate them and focus on eligibility, then problems arise. The main problem in my submission is that if one focuses on eligibility, then, to put it simply, anyone, any applicant, potentially, with the starting point of any factual matrix, even one where they don't have a partner, would be eligible to apply. It is in my submission the word partner that forms what Upper Tribunal Judge Blum characterised as the conditioning. So it sets the condition, essentially, which really makes sense of that phrase.
So the phrase in 23B3.
Yes, so Roman 3, if I could call it that for a moment. And we see that. It's worth going to this in my submission. In Upper Tribunal Judge Blum's judgment, at paragraph 32, which is at the bundle, page 50. It's the line, second line in the paragraph, begins on the most expansive view. Anyone could be considered as being eligible to make an application for a particular immigration status. And then, towards the bottom of the paragraph, sentence beginning, this suggests that the threshold criteria that partner, that must be met, I beg your pardon, to make an application eligible to apply for leave to remain as a partner, is that they meet, at least on a prima facie basis, the meaning of partner. I make that submission at the outset simply because in his skeleton argument at paragraph 26, my learned friend says the words eligible to apply in paragraph ELTRPT 2.3 of Appendix FM are important and refer to a situation where an application is possible. That assertion in my learned friend's skeleton, in my perception, wasn't followed in his oral submissions with as much force. I think, as I understand it, his submissions relate principally to context.
I have, speaking entirely for myself, I have real difficulties with this phrase, eligible to apply for. Because it means the judge then, the upper tribunal judge, has to struggle with what that means. And in this paragraph 32, he says it's got to meet on a prima facie basis the meaning of partner. And And then his conclusion is if it is readily apparent from the information contained in the application and any information available to the Secretary of State that they meet the definition of partner. I mean, is that a happy state of affairs in this context?
Well, lady, I think, in fairness to learned judge, what he is trying to do is make a distinction. This is in reference to the words eligible to apply, between a situation where there is simply an eligibility in the sense that you are entitled to make an application.
Everybody's entitled to pay their £1,062.50.
Precisely.
I wonder whether to apply, whether those words, does it mean eligible for leave to remain? Eligible in the sense that it's a you meet the requirements, or you say it means something less? Do you?
I think what if one reads all of what the learned judge says, beginning with paragraph 32 and ending, actually with the end of the judgment itself, I think what the learned judge is saying is that the only proper construction of that entire phrase, eligible to apply for leave to remain as a partner, is referring to meeting the substantive conditions for leave to remain as a partner. So,
meeting. I mean that, but that's not what he said.
It's
There's
not
some
exactly
sort of,
what he says.
you know, you have a prima facie look at not only what's in the application, but also anything that may be available to the Secretary of State in determining this threshold question. Anyway, that's what the judge. You say the judge was right, do you?
In terms of making
Linking
some
to
sense of the
partner,
words
yes.
eligible to apply, the judge is right insofar as you would not be eligible to apply if you did not have a partner. So to get it off the ground, you have to have a partner of some sort. There has to be a prima facie relationship.
Would it affect the outcome of this appeal if eligible to apply actually means eligible? You meet the requirements for leave to remain as a partner, not just a prima facie case?
Well, that would have an impact, I accept, if it simply said eligible as a partner, because that would connote eligibility in terms of meeting the conditions as opposed to eligibility in the sense of being able to make an application.
Well, it would fall quite fairly and squarely within the provision of the appendix, which ELTRPT 2.3, not the partner of the applicant, and the applicant must not be eligible to apply for leave to remain as a partner. Eligibility to apply as a partner on the strict understanding of Gen 1.2 would obviously fall foul of these rules. You don't need any aid to construction, do you? If you are eligible to apply as a partner on the basis that you've lived with somebody continuously for 2 years, I know that's not the case here, but quite clearly then you fall under subsection 3.
Yes, he would accept that. Ultimately, there might still be a degree of controversy about what partner actually means in this context.
Of course.
In fact, is what I'm really saying in this preliminary part of my submission, is that the focus of the court's inquiry, in my respectful submission, should be on the word partner, because if we look at eligibility to apply, it doesn't, well, it's slightly vague. It can only be framed in a coherent way if read conjunctively with the word partner, and therefore the inquiry should be on the word partner.
So, my lady earlier on in the discussion with Mr. Zain Malik suggested that the wording of subsection 3 of 2.3b ELTRPT could mean strictly applied eligibility to apply rather than eligibility to be considered. And that's the difference between the Article 8 consideration. So you'd say that whichever way it falls, either you've got to fall within the definition of 1.2 because you're not eligible to apply pursuant to section 3.2, subsection 2, you're only eligible to be considered. And so it's saying eligibility to apply as a partner, but it's the application rather than the consideration.
My lady, yes, and if one looks at paragraph 35, seen as we're at this part of the bundle. So it's bundle 51, paragraph 35 of Upper Tribunal Judge Blum's judgment. That is, in my view, what the learned judge is getting at. So he says, I can't find any phrase or term within ELTRPT 2.3 or section ELTRPT. Then he goes on to say, the respondent has pointed out that Gem point 3.2 enables her to grant LTR as a partner if an applicant does not otherwise meet the requirements. Then I think this is the point. He says Gem point 3.2 is, however, designed to enable an Article 8 proportionality assessment to be undertaken within the context of Appendix FM. It's not concerned with the formal requirements needed to make an application.
Yes, thank you.
It's not articulated precisely.
It goes to my lady's point.
Says, but in my submission, that is making more or less the same point. So I make that initial submission simply to, well, really as an overarching point, that the focus should be on the word partner. Now, thereafter, in my submission, Secretary of State's case really falls into two categories. There are submissions that relate to the wording of the rule, Roman 3, if I can call it that, so ELTRPT 2.3, Roman 3, as the wording of that rule, and, well, for now I'll just say that rule itself, and context. And in my submission, when one looks at the wording of the rule, which naturally is the starting point, the Secretary of State cannot possibly succeed. In fairness to my learned friend, I think he accepted, in my perception, that it's really an argument based on context, but nonetheless, in my submission, it's helpful to actually look at the wording of the rule because it shows just how conspicuously absent the words, which I would say, in effect, my learned friend invites the court to read into Roman 3, actually are. That's important in my submission because it tells us what draftsperson's, albeit a policy draftsperson, not draftsperson of statute, intention actually was. So with that in mind, and I appreciate we spent some time on this earlier, the point that I make in paragraph 15 of my skeleton is that when we compare Roman 2 with Roman 3, there is a conspicuous difference.
And you'll have heard that we challenged Mr. Malik on that.
Well, Roman 2 is, well, in fact, forgive me if I just go to the actual rule itself. This is authorities bundle, page 40, subheading ELTRPT.2.3, subparagraph B. The parent or carer with whom the child normally lives must be a British citizen. And then Roman 2, not the partner of the applicant. So that's referring to the person who's the parent of the child on the basis of whom the application is being made, not the partner of the applicant. Then it gives a specific definition that partner includes a person who has been in a relationship with the applicant for less than 2 years prior to the date of application. It's not, I accept, an explicit reference to Gem Point 1.2. It doesn't say, for example, which here includes a person who does not fall within the definition of a partner in Gem Point 1.2. But that, in my submission, is what it's getting at when it refers to a relationship of less than 2 years. But that wording is absent from Roman 3. And in my submission, that's important because Gem Point 1.2 is it's the second provision in the appendix. It sets out an autonomous definition. Thus, the way that the appendix has been drafted, it is intended, the definition that is in Gem Point 1.2, to permeate through the appendix. There's a doubt about what partner means in the appendix, and the starting point is that one bolts back to Gem Point 1.2. Furthermore, what I say in my skeleton is that it's the inference that one has to draw from the absence of words similar to those in Roman 2 in Roman 3. It can only mean, in my submission, number one, that the draftsperson did not intend for the term partner in Roman 3 to have the same meaning as in Roman 2. If that's correct, the Secretary of State's appeal cannot succeed in my submission. But I accept it could be an error in the sense of it's loosely drafted, or maybe for whatever reason just did not make it into Roman 3. That might
You don't want to speculate about that, do you, Mr.
Well,
Malik?
no, I don't want to speculate, but what I say is it's conceivable.
Yeah,
Well,
well,
so maybe, but
that's against your own argument.
it's not what it says. And your argument is just let's look at what it says.
Yes.
I can't see the point of you going on flights of fancy about what the relevant Secretary of State might or might not have made an error about.
Yes, but sorry, that, my lord, is my submission after the word but. The but is that the intention of the Secretary of State, so far as this court is concerned, cannot be divined, to use the language used by the court in Mahad, by reference to what the Secretary of State or the draftsperson more accurately might have intended. It has to be by reference to the language. What I say in paragraph 16 is that when we get into the notion of error or oversight, that becomes really a problem which it's impossible for the court to resolve in the Secretary of State's favour, just based on the wording alone.
Yeah, so we've got that submission. And you support Upper Tribunal Judge Blum's judgment, which coincides with your submissions on that.
Yes.
Yes, as it does in relation to, and you've already taken us there, Gen. 3.2. So, speaking for myself, I think it might be helpful for me to hear any amplification you want to make on paragraph 20 of your skeleton argument. Mr. Zayn Malik has very properly pointed out that it is not possible for the Secretary of State to depend upon the policy documents for interpretation of what otherwise is an unambiguous part of the rules in the appendix. So you're saying in paragraph 20, Secretary of State clearly does rely on her policy document, brackets, whatever she's saying.
Well, my understanding of my learned friend's skeleton argument, because in fairness, I think probably this was pursued with a light touch in submissions, is that the policy illustrates how the rule is supposed to work. But in my submission, in fact, we end up at the same point, that the meaning of the policy has to be ascertained by looking at the wording in the context. So context-based submissions I accept are relevant, and obviously I'll address you on some of those. But the policy is simply neither here nor there. It may set out what, at the time that the policy was written, was in the Secretary of State's mind in terms of how she saw the policy operating. But it's not, and I use the word with a degree of caution, an admissible consideration to the construction of 2.3 Roman 3. It's very...
Yeah.
it's
So,
almost,
as I said, Mr. Malik, I think what you're trying to get at in paragraph 20 is, regardless of Mr. Zayn Malik's protestations that the Secretary of State knows that she can't rely upon the policy documents to interpret or construct the clear wording as you would have it of these rules, this appendix, is trying to have his cake and eat it. Is that what you're saying in paragraph 20?
yes, what I'm saying in paragraph 20 is that, in effect, what the Secretary of State is saying to the court is, had the rules been drafted in a different way, this is what they might have looked like. They might have mirrored the policy, and that somehow can assist the court in construing 2.3 Roman 3. I have difficulty understanding exactly how the argument is pitched, because, as I said, it's there in the skeleton. The policy document is in the bundle, but I don't understand that it's been pursued with any vigour today.
No,
So,
well, it hasn't. So that's very helpful. Now I know how you're putting that. Thank you.
So, my lady, I've addressed you on wording. If I may address you, please, on context.
Yes.
This issue is, there's no subheading in my skeleton, same context, for which I apologise, but it's paragraph 17 to 21, my skeleton, that deal with context-based points. So, first issue is paragraph gem point 3.2.
Yes.
There is an issue about gem point 3.2 that has been discussed at length in exchanges between my learned friend and the court. You and your colleagues have asked me about it already, and I took you to the excerpt in the judgment of Upper Tribunal Judge Blum.
Yes, you have.
So I won't repeat my submissions on that issue, but there is another point which in my submission emerges, which is that there is nothing which ties paragraph gem point 3.2 to E LTRPT 2.3 Roman 3. At the outset of my learned friend submissions, the court very properly asked, well, we start off with gem point 1.2. There's a meaning partner there, and it says, unless a different meaning applies. Is there anywhere else in the appendix where a different meaning might apply? Well, in a sense, I accept that gem point 3.2 is an instance where a different meaning of a partner applies, because gem point 3.2 is a catch-all provision. It's a residual provision where if you don't meet the requirements of the rules, but for example, in some sense, if you have a partner such that your family life is engaged, then there is a consideration of that relationship by the decision maker. But there is nothing that connects that rule no wording that connects it to Roman 3, 2.3 Roman 3. Simply, that simply is my submission on that point.
Thank you.
If I could address you, please, on abuse.
Yes.
Well, the Secretary of State says an applicant might hide a relationship to benefit from a more generous route. So, for example, if you take, choose masculine, that's my client's gender, Mr. X, and Mr. X has been cohabitating for 2 years or more. For example, does not meet the financial requirement. So Gen. 1.2 definition met. There's a problem. Substantive requirements of the partner route, the financial requirement is not met. Then would Mr. X seek to circumvent that by making an application under the child route? My submission is that there is no general rule that I'm aware of, and I'm not aware that my learned friend has brought any such rule to the court's attention, that an immigration rule, any particular immigration rule that says, must be interpreted so as to exclude every conceivable permutation of abuse, even if there is nothing in the wording of the rule itself. So I accept that there would be context and word specific, there may be situations where there is an obvious mischief, where the court may say, well, the construction of the rule that does not permit that obvious mischief is the one that must be preferred, even if it's not entirely clear from the words themselves, but there's no general rule. So it's not like, for example, in tax law, where there is an overarching anti-abuse rule that permeates its way through many statutory provisions. There's no equivalent in the construction of the immigration rules. And of course, as my Lord observed, there are many ways in which abuse can occur. It could range from something simple, such as forgery of a document, material non-disclosure, for example, the existence of a relationship. The list probably is very, very long. The key point is that there is nothing in the wording of Roman 3 that addresses specifically or even hints that the draftsperson had in mind the sort of mischief which in these proceedings the Secretary of State highlights. Just going back to the policy document for a moment, this is, in my submission, an example of the Secretary of State trying to reverse engineer the meaning from potentially undesirable policy outcomes. So the Secretary of State is saying, well, because the construction of Roman 3 that Mr. Khattak invites the court to adopt, essentially the tribunal's construction, might give rise to one or a number of potential undesirable policy outcomes that somehow informs the meaning of the rule. It's a very general submission. The Secretary of State, in my submission, and it should respectfully, in my submission, be rejected. If I move past paragraph 20 of my skeleton and go to paragraph 21, this...
Well, you hear, mate, what my lady made. There's a reason why one might regard the parent route as, in inverted commas, easier, because of the importance of the parent-child relationship.
Well, my Lord, I don't, of course, presume anything about what the court's view may be, but what I will say is that I cannot really articulate it any better than what I've written in paragraph 21, my skeleton, and by adopting the observations that my lady made of my learned friend, there is a principled reason for that distinction. It's not arbitrary. And in my submission, it is apples and oranges, or
Pears, I think it was.
well, it was pears. Forgive me, but it's different. The child root is separate, and it's actually very clear. One looks at the rules overall. Partner root, child root. Why? Child root might be more generous, and in my submission, it's not the strongest of points for the Secretary of State. Where I do accept the Secretary of State has a point which on the face of it appears attractive, is the point that was made at the end of my learned friend submission.
Page 44.
ELT, so EILR.
What do you say about that?
Well, the point wasn't made for completeness, and again, it's not criticism by me, but it was not made for the upper tribunal. I understand the point to be that, in effect, an applicant can be on the child route, and then a relationship of sorts ensues, and then essentially by the time they come round to applying for ILR, they have completed 2 years, and therefore, because under EILR PT 1A, read in conjunction with EILR PT 1.3, forgive me, sorry, 1 small a, read in conjunction with 1 big A, they have to meet all the requirements as at the date of ILR, they would be prevented from applying on the parent route, because by that date they would meet the requirements of the partner route by virtue of 2 years cohabitation. My submission, first, it's an argument based on context alone. It's wholly, it's in the same scheme of provisions, I accept that, because there is a natural progression from leave to enter, leave to remain through to ILR, so that I accept. It's a different provision from Roman 3, obviously. But my main submission on this is that it's a point which may not actually come to fruition. It may or may not be the case in the future. So just to take the example again of Mr. X, if Mr. X applies as at today's date with a non-Gem point 1.2 partner in the background, so less than 2 years cohabitation, he asserts, well, that's not a partner for the purposes of this appendix, and I'm going to apply therefore on the basis of my child, and I want to complete my ILR on that basis in a couple of years' time, or in 2.5 years' time. Mr. X may or may not be in a relationship with that partner come the point at which he chooses to apply for ILR. He might be. I accept that. But he might not be. And this goes back fundamentally to the distinction that is made in Gem point 1.2 between partners who have the quality of being durable by virtue of marriage or civil partnership or cohabitation in excess of 2 years, and general partners, people who in the vernacular are partners but not in the autonomous sense. It's uncertain, and it relates to a point in the future which has to be, by virtue of being the point in the future, speculative.
Well, one of the alternative ways of arguing this would be, wouldn't it, Mr Malik? And you deal with it on the hoof, as it were, since it wasn't raised in the tribunal below or in the or otherwise saved for the appeal, that given that this is, if Mr Zayn Malik's interpretation is correct, so punitive to a parent, that would rather undermine any suggestion that they were seeking to take advantage of the parental application. Because if they are deemed to know the consequences, then, as Mr Malik said, why would they apply as a parent at all? And it could be because they are being, as it were, complicit with what appears to be the requirements of the appendix and the intent behind the appendix. So they are being, in one sense, entirely proper and genuine in their application. It can be seen both ways, can't it? So it's as much as a point to you as it is to Mr Malik.
Lady, I accept that. The other point is that, of course, we are not dealing in this case with a decision under the ILR provision, if I can call it that. So my client did not apply for ILR in this case. He applied for limited leave to remain, yes. And he was not refused under EILR PT.1.3, 1 small a or 1 big A. Now, I'm limited. I'm going to limit myself on following submissions, saying simply this, that if a decision was made to refuse under that ILR provision for the reasons that my learned friend has given in open court today, then it may not be, but it may be that would be open to challenge. It's not the locus of this appeal. But it may give rise to some controversy. So
I think Mr Zayn Malik's only raising it as an aid to what he says the construction should be.
Absolutely.
But, in doing so, there are two sides to the argument. That's the suggestion I put to you, and I think you've agreed with that. That this was somebody who was applying for limited leave to remain, and it may be that that's all he wants. It may be that his child is 14, and so in 5 years' time, his child will be a teenager and elsewhere. I mean, what you're saying is we shouldn't speculate on what the intent is behind the initial application.
My lady, respectfully, yes. To put it very, very simply, the relationship with the partner, the non-jump 1-2 partner of today, could break down. Those are, my lady, my submissions, unless I can assist the course any further.
Well, you're right to say we shouldn't speculate about the intention behind the application, but just nuts and bolts. What is it that Mr Khattak wants from this appeal? He was granted leave to remain for 30 months under the 10-year partner rule. He was refused leave to remain under the 5-year parent route. Just in practical terms, in a nutshell, what's the benefit to the quashing of the decision?
Well, lady, I don't have. Well, I'm not sure it would be appropriate for me to.
No, well, don't. If it's not appropriate, no, don't then. All right.
But as I forgive me, I don't.
What's the practical difference?
Well, I don't want to or be seen to be dodging the question, but I think this goes back to my earlier point that the Secretary of State has not made a decision in this case to refuse under the ILR provision. Now, if she refused for the reasons that my learned friend has given in open court, which I accept, and very properly advanced as submissions in support of his construction of Roman 3 of ELTR PT 2.3, if a decision was made under the ILR provision, then for those reasons, that it may be that Mr Khattak has something to say about it. That's probably the best way that I can put it.
Anything further? No, thank you very much. Anything further?
Can I just go back to the crucial paragraph in E-LTRPT.2.3? Eligible to apply for leave to remain as a partner. If it simply said eligible for leave to remain as a partner, that would probably be easy, because eligible has a meaning. If you're eligible to do something, you satisfy the relevant or necessary conditions. That's eligibility. The words "to apply" don't sit very easily with that. I mean, the necessary conditions to apply for leave to remain as a partner, well, arguably anybody at all could. And there are eligibility conditions, and if you took it into your head, maybe you have, to apply to sit as a recorder of the Crown Court, you have to satisfy, I think it's 7 years post-qualification experience. A pupil in your chambers could think, oh, I'd like to be a recorder. And they could apply, but of course they get nowhere, because they didn't satisfy the eligibility criteria. They didn't satisfy the necessary conditions. So what does "to apply" mean in the context of this?
I'm not sure, my lord, it adds a great deal. Now, if it was a case that there were conditions, forgive me, if there were facts which rendered an applicant ineligible, so in your analogy, for example, if you're not above a certain age, for example, then you're ineligible, that would be clear. But eligible to apply, I agree, simply connotes almost a physical and technical ability to make an application. But that really goes back to my initial point at the very outset of my submissions, that, and I think, in fairness, this is probably what Tribunal Judge Blum was getting at as well. The focus of the inquiry should be on the word partner, because the words eligible to apply don't really coherently add much.
Does it affect your position, just to repeat the point, because you could see that I don't find this idea of prima facie or readily identifiable from the information available. Does it damage your position if it actually eligible to apply means, as my lord suggests, eligible, i.e. meets the requirements? We know in these rules sometimes it says meets the requirements of, and elsewhere it says eligible to apply, so maybe there is a difference. But does it affect the merits of your position if eligible to apply simply means eligible?
Respectfully, my lady, no, I don't accept that it does, because we still have to contend with the word partner.
Yeah, no,
I don't think that the issue of whether partner is 1.1.2 or some other residual meaning can be determined by reference to the word eligible as opposed to, well, it doesn't turn on eligible versus meets. It still goes back to what a partner is.
Yes.
And that's why I focus my submissions on that point.
Thank you. Thank you. Sorry.
Anything further?
No, thank you.
Thank you very much indeed, Mr. Malik. Thank you. So, Mr. Zain Malik, how long will you be in response?
5 minutes. I have 4 very short points. I can make those points in 5 minutes, but I'm entirely happy to come back at 2 o'clock if the court prefers.
Well, if it literally is 5 minutes and subject to anyone else's convenience, more important than ours, are you okay to stay on? All right. 4 points then, Mr. Malik.
First, ladies, my lord, my learned friend focuses heavily on the fact that there is no express exclusion in Roman 3 as it is in Roman 2. Of course, that is the main point against me, and I answer that point by saying, firstly, that...
Well, this is what you've already argued, so this is a response
Yes.
rather than a reiteration of your arguments, Mr. Malik.
Yes. You have, of course, my detailed submissions, but just to answer the specific point that my learned friend made, I ask you respectfully to actually compare the opening words of Roman 2 and Roman 3. You'll see that Roman 2 simply refers to not the partner of the applicant. There is no reference to eligibility to apply under appendix. And given that the reference to appendix and eligibility to apply is missing from Roman 2, it is understandable why the author would insert the words that are in the brackets. But the words eligible to apply and the reference to under this appendix in Roman 3 means that express exclusion was not required for the reasons that I have given. It is eligible to apply for leave to remain as a partner under this appendix contemplates an applicant who does not meet the definitional requirement to still be able to apply under the appendix. Second point, my learned friend made a submission in response to my lady's question about the policy document. I'm not relying on the policy document as an aid to construction as I submitted in my skeleton. I'm simply saying that what is said in the policy is the correct construction. I felt obliged to bring the policy to the court's attention. Third point, my learned friend made a submission that there is no principle that rules should be construed with the objective to avoid abuse. My lord, my ladies, my lord, the principle is in Mahad, paragraph 10. Rules ought to be construed sensibly and recognizing that they are statements of the Secretary of State's policy. But if the court requires a further clear express principle, it is behind tab 1, the very first paragraph, the very first rule, Gen 1.1. So this sets out the general purpose of the entire appendix. The court has seen the first sentence. But in response to my learned friend's point, may I ask the court respectfully to read the paragraph in full. You'll see that the entire purpose of this part of the rules is to balance the Article 8 rights with the economic well-being of the UK and to prevent crime and disorder. And to take account, to reflect the public interest considerations in the statute, which includes that maintenance of effective immigration control is in the public interest. So that is the whole purpose of this part in my respectful submission. If two plausible constructions are available to this court, the court should opt for a construction that is consistent with this objective and minimizes the possibility of abuse. And the fifth and final point concerns what my lady put to my learned friend towards the end of his submissions by reference to the settlement provision. And my lady was troubled with the point that the effect is so punitive as to why would an applicant would seek to take an advantage. The first thing that I should clarify is that there's no suggestion at all that this application is abusive or Mr. Khattak is trying to play the system. That is not what I say. And the submission that I made, and it's set out in my skeleton, I had an applicant in mind who would conceal the partner relationship for good 5 years and get the settlement as a parent by circumventing the financial requirements. So that is the sort of abuse that Roman 3 seeks to address. And if that is not the purpose of Roman 3, then I ask respectfully the court to consider what else is the purpose of that rule. Accepting the upper tribunal's construction, in my respectful submission, will render Roman 3, will take away the force from Roman 3 that is intended. Ladies, my lords, these are my 4 points in reply.
Thank you very much indeed. Thank you both very much for your submissions, both oral and written. It's obviously a case that we will want to reflect upon. We will get the draft judgments to you as soon as we may. Once you receive them, it's an opportunity for you to correct our English, not our reasoning. It is obviously something that we hope, that is the judgment, will lead you to be able to draft an order reflecting that judgment. If there are any outstanding applications, please can they be made at first instance in writing. Thank you all very much. Thank you very much for sitting on again. Thank you.